In the late 1800s, the Furries filed claim on the property, and they owned it up until we bought it in 1959. They're an old family that originated in Phoenix, and we acquired the property from them when they retired from their cattle business, and we've kept it in our family for the last 50-some years now. But there's no one to carry it on in our family, so I decided to sell it. Our original plans was, we had a cattle operation. Our original plans were for a grazing property, to graze cattle. They changed when I became old and retired and quit the cattle business. Senate Bill 100 limited our opportunities on selling the property to a very great extent. Ballot Measure 37 passed. We were able to get a waiver from the county and from the state, enable us to develop it into different lots. We've probably invested well over $500,000 to get it developed. Judge Panner ruled that our waivers were valid and enforceable, and we're going to stand by those waivers and ask the county to honor them. I'll still sell the property if the rulings are overturned. It'll be a lesser sum of money. The value won't be there unless we get the waivers honored, and my retirement plans will be greatly altered.
The original plans was to create a guest ranch for families that could come and get out of the city and have a place that really the environment was so magnificent that they would enjoy coming back. And we've had guests come back for 30 years in a row. We originally had 692 acres, and then since then have added on to it to where it's right at 1,500 acres now. We were probably one of the very first properties that felt the impact of Senate Bill 100, in that we proceeded to file for permits to go forward with an additional log house, and they said, no, not now. You can't do anything more with your property. At the time that I purchased the property, it was unzoned, and stamped right on the deed, it said unzoned. So to me, that meant that there weren't any restrictions as far as what type of business that I would want to pursue or project that I would want to pursue. And in this particular property, we were either downzoned, rezoned, farm zoned, overlaid, about 5 different times on each piece of property. When Measure 37 was passed by the citizens of the state by an overwhelming amount, that opened up the door for us to go forward. That's my friend in the background. And so we did file at that point to go forward with some additional buildings and housing and other facilities here on the property. So we filed that claim, and Jackson County addressed that claim and approved it. Measure 49 was a shock, because I think that all of us understood that when the county approved the waiver and stamped it on the deed, that the county had approved the request for the development that we went forward with. We felt that was a done deal. And then when the governor and the legislature got into being and decided that they didn't like what was happening with the claims that were filed, they changed the law. It went to the people, but the the way that it was worded and the things that were in the title, I think a lot of the people misunderstood what was going on. I'm 78 years old now, and I would like to be able to do something in my estate plan that would help my children or friends or the different folks that have enjoyed this place for 30-some years. But until the commissioners understand that Judge Panner, a federal judge, said that what they gave me is a valid contract, then I can't do any of that. Since 73, that's 35 years ago, is when they first started telling me what I could or couldn't do on my property. I don't like it. I'm a good steward of the land. I know what works, I know what doesn't work, and for me, for the state or the governor or the legislature to tell me I can't do anything with my land is not right.
I got involved in this case because I got very concerned once I learned that the state intended to apply Measure 49 retroactively rather than retrospectively. Most lawyers, and I think most citizens that read all the information that was put out on 49 believe that if they had vested rights under 37, that they would not be taken away. However, once we understood that 49 intended to take all those rights away, or that the DLCD's interpretation of 49, then I got very concerned because I think it was definitely a violation of constitutional rights of all the people involved.
I was sitting retired, living in the woods 12 miles downstream from Grants Pass, very happy until Measure 49 passed. And I was frankly outraged by what Measure 49 was attempting to do. And just driven by that outrage, I undertook to reactivate all my licenses, bring myself up to speed, studying what 37 and the associated law might mean for about 6 months, and just paying attention to this issue. And this issue drives me. I think it's a violation of constitutional rights, and I think that the federal court saw it the same way.
There's actually four of us. There's Jack and Dave Smith, and then Bill Bernard, who is a blind lawyer in Utah, and myself. And we were sitting here one day once the federal court agreed to take this case, and we had Bill Bernard on a conference call, and we said, well, here we are. All of us are in our late 60s, except for Bill Bernard's a little bit younger. And we said, here we are, 3 old farts and 1 blind lawyer, and we got the biggest constitutional law case going in the state of Oregon. But the reason I thought we could win is because I think sooner or later the Constitution will win.
When we started looking at the circumstances of this case, we felt that the law was on our side, and you always hope that that will be enough to win a case. Many times it's not enough, but fortunately we found a judge who agreed that the Constitution was the underlying law of this country, and basically said it's pretty simple. You've got constitutional protection, those rights are still valid.
As documents are filed in the federal case, an email notice is sent to every attorney. And so, of course, I found myself 6, 7, 8 times a day checking my email, looking for something out of the court. And, of course, days would go on and nothing would happen. And finally, one afternoon, I checked the email and there was a notice, activity in case number X, Y, and Z. And so I went to the court website, I pulled it up, and there was the decision. And I'm going to tell you, I ran out of the office into the driveway, and I was just hooting and hollering with joy.
Bob Robertson called me up and said, we have the decision, and he didn't tell me what it was, and he said, we won. And I just was kind of speechless, because I was afraid to really hope that we would win. But then I called Jack and he let out a whoop. So from there on we decided now we're in a different position. We can now deal hopefully from a position of strength.
We've gotten to the point that we're brainwashed, that the land use agencies, the DLCD and the LCDC and the DEQ and all the regulatory agencies can do whatever they want to. They can trample over our individual rights. And lawyers have come to the point where they don't even question the constitutionality. These regulatory agencies have had their say and had control for so long that it's almost like most lawyers feel like it's not worth trying to fight the system. You're going to lose. And I felt like for once that the people could win one.
Judge Panner issued his findings of facts and conclusions of law on November 12th, and then followed up with his judgment on the 19th of November. And a couple of days later, these other groups, various environmental groups, entered into the case by trying to intervene. They were after the judgment was entered that they first appeared. Judge Panner denied their motion to intervene, but now they've appealed that to the Ninth Circuit Court of Appeals. I think it's unfortunate that what they do is they just totally frustrate the system for these people that have these claims, most of whom are in their 80s or even older. And it's, as they say, justice delayed is justice denied. Well, you've heard that Judge Panner said that the state of Oregon doesn't have a dog in the fight, and you've heard from some of the citizens that do. Well, folks, we all have a dog in this fight, because when someone's constitutional rights are taken away from them, it affects us, all of us. So what we need to do is we need to get motivated. We need to contact our legislature, and we need to let them know that they've got to fix this mess that's been created with Measure 49. Every one of us should do whatever we can to make sure that no one's rights are taken away, that the Constitution prevails.